I'm Jay Metter, CFP again, and here again with my friend and attorney, Chris Peterson. And today the subject is wills. So tell us a little bit about wills.
Okay, wills are something that most people are kind of familiar with, the concept of wills. So a will is basically a legal document that meets certain formalities where the person sets out what they want to have happen with their estate, who they want to manage and operate their estate, and who they want to receive their estate after that they've passed away. And so as long as you meet the formalities of what is required for a will, then you're going to have a valid will.
Okay, I know that they come in different types. Tell us about that a little bit.
Yeah, so there's what we refer to in the office as good types and bad types. So let me tell you what the good type is. A good type is a statutory will, which just means it's a written will that meets all the statutory requirements. Each state has a different set of requirements for what makes a valid will. So the requirements in Texas may be the same or may be different than it is in Oklahoma. Actually, in Oklahoma it's the same, but it may be different than what it is in Florida. Florida is different than Montana. Montana is different than New York. Everybody's different than Louisiana. So, but a statutory will is just a will that meets that individual state's requirements to be a valid will. So the good type is the statutory will. The bad type is either oral will or a holographic will. So a holographic will is a will that you handwrite. There's not much formality to a holographic will. It actually still has to meet the requirements of the statute for being a valid holographic will. Mm-hmm. And holographic wills are kind of a mess. The thing that we see often with holographic wills, kind of the problems and why I encourage everybody not to do them, is they typically don't set out all the things you really need to know. So, for instance, there are different forms of probate that we have in the state of Texas. What you can do as part of the probate process is you can nominate an executor in your will, and then you can specify whether or not they have to post a bond. So when people do, and most people don't want their executor to have to post a bond, but when people do holographic wills, they're not attorneys, and so they don't think about it, and so they nominate an executor, but they're silent about what the bond requirement is. And so if there's no waiver of the bond, then your executor has to post one. That's the way the law works. The other thing is holographic wills, what we often see is they don't completely dispose of the estate. They mention one or two things, but they don't have what's called a remainder clause in them or a residue clause. And so they don't really give the court instruction about what to do with every asset that somebody owns. The third thing that we often see with holographic wills is, unbelievably, even though they're called handwritten wills, is they're often not handwritten. Someone will type them out on the computer and then sign them, not have them witnessed or notarized in any way, and so they don't meet the requirements of being completely in the decedent's handwriting. Even worse is, a lot of times we see handwritten wills that are done sort of at the last minute. Mom or dad is on the deathbed, and so what the child does is they pull out a piece of paper, write it in their handwriting, and then get mom or dad to sign it. Well, that doesn't meet the requirement for a holographic will because it's not in the decedent's handwriting. So if you're going to do a will, please don't advise your client to do a holographic one because they're almost never right. They almost never dispose of everything. They don't take advantage of all the different provisions of the probate code, and they tend to be kind of a mess. Now, oral wills are even worse because what an oral will is basically, I'm on my deathbed and I let you know what I want done with my estate. Well, when we see oral wills probated, what we generally see is one child arguing with all the other heirs about what mom intended. Well, mom said I get the house. No, she didn't. And it ends up in this big he said, she said argument about it. And so, again, if your client wants to do wills, what you need to do is you need to advise them to get an estate planning attorney, do statutory written wills that meet all the requirements of the state where they are located, where they're a resident of. And you need to tell them that if they want to do an oral will and a holographic will, that they need to find another financial planner.
Right. Well, but what about those great online wills? Are the ones that you can go down to Office Depot and buy? Those look very official.
You know, here's what I love about people that try to do their own estate planning. Well, I have a friend, good friend, who's an estate planning attorney over in Austin. He always says that you should do your wills the day after you do your own dentistry. If you'll do your own root canal, then you should do your own will, because it requires the same level of education and knowledge. I personally love it when clients use and do wills themselves, especially if they do it out at Hastings Bookstore or Office Depot, because they almost never do it right, and we make a lot more money when your probate is a mess than we make off of writing your wills the first time.
Right.
So I actually we were doing wills for one of my best friends, and he likes to give me a hard time because apparently everybody that I'm friends with is like that. And especially you. But it wasn't Jay that called me. But anyway, we were in the process of doing wills for he and his wife, and they have 2 small kids. And he calls me up, and he's at the bookstore, and he says, "Well, Chris, this is going to be great, and I know what you're charging me for the will, but I stumbled upon this deal, and they've got this book, and it's marked down to $19.95, and that's a lot cheaper than what you're charging me, so I'm just going to go ahead and buy the book and do my will myself." And I said, "Well, you should totally do that. You should totally do that." And he says, "Well, I'm really surprised that you would say that since you're doing the wills." I was like, "Oh, no. We're close friends. We vacation together. We go stay at their house, vice versa." I said, "Well, I know who your wife's going to hire for your probate. I'll make a lot more money on probate because you'll screw that thing up good. So you should totally do that. It's either pay me a little now or pay me a lot later. You want to buy the pound of cure instead of the ounce of prevention? Knock yourself out. I'm going to make a lot of money off of you."
I have one word for my clients when they talk to me about the online wills and that sort of stuff. I just look at them and say, "No." What? No.
The problem isn't the will product themselves. It's that clients most people, they don't have a background in this. They don't know the terminology, and so they don't fill the forms out right. They don't know about all the consequences of what they're doing. Like when we talked about gift taxes, people don't know about the gift tax issues. Well, that lack of knowledge bites you in the rear end when it comes to estate planning. They don't, those things are written for all 50 states, so they don't really realize that Texas law may be a little bit different than what Montana law is or California law. And there's a lot of times what we see is those products don't take advantage of things that are available under Texas law. I was reviewing one the other day, and we haven't gotten into this yet, but we will in a minute. They had done a revocable living trust online, and it was fine. I mean, the revocable living trust worked, except Texas has this little provision in the Texas tax code that says that if you transfer your house into a revocable living trust, it has to have certain language in the trust in order to retain the homestead exemption on your house. Well, theirs didn't contain that provision. Well, why didn't it contain that provision? Well, because they took it off a bookshelf and they did it themselves, and they didn't know that such a provision existed. Well, in this area of law, ignorance of the law is no excuse. The IRS does not care that you don't have a background in it. they're going to charge you the taxes that you owe because of your ignorance. And so we see that ignorance getting in the way when people try to do their own wills. The other thing that we see is that they're not sure how to execute the wills properly, and so we see a lack of following the formalities. So they won't have the right number of witnesses, they won't have what's called a self-proving affidavit, which we're going to talk about in a second, and so the will doesn't meet all the statutory requirements, and again, it's just a pure lack of knowledge situation.
Let's take a small portion of your portfolio and use that money to pay an expert to protect the rest of it, okay? Anyway, so what are some of, obviously, just some of the pros of wills?
Okay, well, probably the number one kind of pro of a will is that it's kind of in everybody's wheelhouse. It's kind of in their vocabulary, and so they're usually comfortable talking in terms of a will. They may not be comfortable talking about beneficiary designation forms or trusts or intestacy or something like that, but they're generally have some knowledge of what wills do. The great thing about wills is that they avoid the intestacy scheme, right? So we talked earlier about that no plan is having an estate plan because the legislature provided you one. Well, a will gets you out of that statutory scheme. So it puts you in control, right? Because you get to name who your executor is, you get to name who you want as your beneficiaries. If you have specific things that you want to go to a specific kid, you want your wedding ring to go to your daughter and your engagement ring to go to your sister or whatever, you can decide those things, and that's within your control. You can make easy provision for planning for taxes under the contour of a will, whether that's estate taxes or other types of taxes. It also can divide the burden for whatever probate costs that you pay. So if you, let's say that in my will I wanted to give everything to my wife, and I wanted to give $100,000 to you off the top. Well, generally what's going to happen is under the intestacy scheme, you're going to get your $100,000. Any costs and stuff are going to be paid out of the residue. Taxes and stuff are going to be paid out of the residue. Well, if I want you and my wife to share equally in that burden, then we're going to be able to make provision for that in the will. So you can clearly set out exactly what you want your executor to do, exactly who pays for what, and who exactly gets what. And so those are all positive things about the will.